hope you're doing well. Before getting into topic, let us introduce ourselves. Myself, Kaushalya, and my stunning team members, Vaishnavi, Usha, and Lokeshwari, are here to present about topic penalties and its procedures under Factories Act. So let's get started. From Section 92 to Section 106 under the Factories Act tells only about penalties to be followed. So here, me and my team to elaborate those penalties and its procedures which have been followed.
Concept of penalties in Factories Act. Rules are an important part of any institution. They help in maintaining discipline and uniformity in work. But nobody can deny the fact that the seriousness of the rules can only be maintained if its breaking leads to some sort of punishments. Under the law, such punishments for breaking a law, rule or contract are called penalties. Penalties vary with the level of damage to the organization, repetition of mistakes, etc. Factories too define certain rules and regulations in order to maintain discipline in the factory. Similarly, the Factories Act has certain rules in the form of provisions, breaking of which leads to penalties. So, let us now see the various provisions related to penalties under the Factories Act 1948.
Section 92 is about general penalty for offences, save as otherwise expressly provided in this Act, subject to the provision of Section 93. If in or in respect of any factory there is another confirmation of any of the provision of this Act, or of any rule made thereunder, or of any order in writing given therein, the occupier and manager of a factory shall each be guilty of an offence and punishable with imprisonment for a term which may extend to or with a fine which may extend to 1 lakh rupees or with both, and if the contravention is continued after conviction, the further fine which may extend to 1000 rupees for each day on which the contravention is so continued. Provided that contravention of any of the provision of Chapter 4 or any rule made thereunder or under Section 87 has resulted in an accident causing death or serious bodily injury, the fine shall not be less than 25,000 rupees in a case of accident causing death and 5,000 rupees in a case of incident causing serious bodily injury.
Section 93. Liability of owner of premises in certain circumstances. Wherein any premises, separate buildings are leased to different occupiers for use as separate factories. The owner of the premises shall be responsible for the provision and maintenance of common facilities and services such as approach roads, drainage, water supply, lighting and sanitation. The Chief Inspector shall have, subject to the control of the state government, power to issue orders to the owner of the premises in respect for the carrying out the provision of subsection 1. Wherein any premises, independent or self-contained, floors or flats are leased to different occupiers for use as separate factories. The owner of the premises shall be liable as if he were the occupier or manager of a factory of any contravention of the factories of this Act in respect of latrines, urinals and washing facilities in so far as the maintenance of the common supply of water for these purposes is concerned. Fencing of machinery and plant belonging to the owner and not specifically entrusted to the custody or use of an occupier. Precautions in any case of fire, maintenance of hoist and lifts, and maintenance of any other common facilities provided in the premises.
Section 94. Enhanced penalty after previous conviction. Firstly, if any person who has been convicted of any offence punishable under Section 92 is again guilty of an offence involving a contravention of the same provisions, he shall be punishable on a subsequent conviction with imprisonment for a term which may extend to 3 years or with fine which shall not be less than 10,000 rupees but which may extend to 2 lakh rupees or with both. Secondly, no cognizance shall be taken of any conviction made more than 2 years before the commission of the offence for which the person is subsequently being convicted.
Section 95. Penalty for obstructing inspector. Whoever willfully obstructs an inspector in the exercise of any power conferred on him by or under this Act, or fails to produce on a demand by an inspector any register or other documents in his custody kept in the pursuance of this Act, or any rules made thereunder, or conceals or prevents any worker in the factory from appearing before or being examined by an inspector, shall be punishable with the imprisonment for a term which may extend to 6 months, or with a fine which may extend to 10,000 rupees, or both.
Penalty for wrongful disclosing results of an analysis under Section 96. Whoever, except insofar as it may be necessary for the purposes of a prosecution for any offence punishable under this Act, publish or disclose to any person the results of an analysis made under Section 91 shall be punishable with imprisonment for a term which may extend to 6 months, or with a fine which may extend to 10,000 rupees, or with both.
Section 97. Offences by workers. Subject to the provisions of Section 111, if any worker employed in a factory contravenes any provision of this Act, or any rules or orders made thereunder, imposing any duty or liability on workers, he shall be punishable with fine which may extend to 500 rupees. Where a worker is convicted of an offence punishable under subsection 1, the occupier or manager of the factory shall not be deemed to be guilty of an offence in respect of that contravention.
Section 98. Penalty for using false certificates of fitness. Whoever knowingly uses or attempts to use as a certificate of fitness granted to himself under Section 70, a certificate granted to another person under that section, or who, having procured such a certificate, knowingly allows it to be used, or an attempt to use it to be made by another person, shall be punishable with imprisonment for a term which may extend to 2 months, or with a fine which may extend to 1,000 rupees, or with both.
Section 99. Penalty for permitting double employment of child. If a child works in a factory on a day which he has already been working in the other factory, the parent or guardian of the child, or the person having custody or control over him, or obtaining any direct benefit from his wages, shall be punishable with a fine which extends to 1,000 or use, unless it appears to the court that the child so worked without the consent or the conveyance of such parent, guardian, or person.
Section 101 is about exemption of occupier or manager from liability in certain cases. Where the occupier or manager of a factory is charged with an offence punishable under this Act, he shall be entitled, upon complaint duty made by him and on giving to the prosecutors not less than 3 clear days, notice in writing of his intention so to do, to have any other person whom he charges as an actual offender brought before the court at the time appointed for hearing the charge. And if after the commission of the offence has been proved, the occupier or manager of the factory, as the case may be, proves to the satisfaction of the court that he has used due diligence to enforce the execution of this Act, that the said other person committed the offence in question without his knowledge, consent, or convenience.
Section 102. Power of court to make orders. Where the occupier or manager of a factory is convicted of an offence punishable under this Act, the court may, in addition to awarding any punishment, by order in writing require him, within a period specified in the order, to take such measures as may be so specified for remedying the matters in respect of which the offence was committed. Where an order is made under subsection 1, the occupier or manager of the factory, as the case may be, shall not be liable under this Act in respect of the continuation of the offence during the period or extended period, if any, allowed by the court, but if on the expire of such period or extended period, as the case may be, the order of the court has not been fully complied with, the occupier of or manager, as the case may be, shall be deemed to have committed a further offence, and may be sentenced therefore by the court to undergo imprisonment for a term which may extend to 6 months, or to pay a fine which may extend to 100 rupees for every day after such expiry on which the order has not been complied with, or both to undergo such imprisonment and to pay fine as aforesaid.
Section 103. Presumption as to employment. If a person is found in a factory at any time except during intervals for meals or rest, when work is going on or the machinery is in motion, he shall, until the contrary is proved, be deemed for the purpose of this act and the rules made thereunder to have been at that time employed in the factory.
Section 104. Honest as to age. When any act or omission would, if a person were a certain age, be an offensible punishable under this act, and such person is the opinion of the court prima facie under such age, the burden shall be on the accused to prove that such person is not under such age. A declaration in writing by a certificate surgeon relating to worker that he has personally examined him and believes him to be under the age stated in. Such declaration shall, for the purpose of this act and the rules thereunder, be admissible as evidence of the age of the worker. And the second category in section 104 is honest of providing limits of what is practicable, etc. In any proceeding for an offence for the contravention of any provision of this act or rules made thereunder consisting of a failure to comply with the duty or requirement to do something, it shall be for the person who is alleged to have failed to comply with such duties or requirement to prove that it was not a reasonable practicable, or as the case may be, or the practicable measures were taken to satisfy the duties or requirement.
Section 105. Cognizance of offences. No court shall take cognizance of any offence under this Act except on complaint by or with the previous sanction in writing of an inspector. No court below that of a presidency magistrate or of a magistrate or of the first class try any offence punishable under this Act.
Section 106. Limitation of prosecutions. No court shall take cognizance of any offence punishable under this Act unless the complaint thereof is made within 3 months of the date on which the alleged commission of the offence came to the knowledge of an inspector, provided that where the offence consists of disobeying a written order made by an inspector, complaint thereof may be made within 6 months of the date on which the offence is alleged to have been committed. That is, in the case of a continuing offence, the period of limitation shall be computed with reference to every point of time during which the offence continues. Also, where for the performance of any act, time is granted or extended on an application made by the occupier or manager of a factory, the period of limitation shall be computed from the date on which the time so granted or extended expired. Section 106A. Jurisdiction of a court for entertaining proceedings, etc. for offence. For the purposes of conferring jurisdiction on any court in relation to an offence under this Act or the rules made thereunder in connection with the operation of any plant, the place where the plant is for time being situate shall be deemed to be the place where such offence has been committed. So, hope you guys have gained some knowledge from our video. We thank each and everyone for watching our video so patiently and also giving us this opportunity to present our video. And finally, stay home, stay safe.